An important category of copyrighted works consists of works of visual art, which are known in U.S. law as pictorial, graphical, and sculptural works, sometimes abbreviated as PGS works. Included in this zone are, of course, paintings, posters, statues, and so forth. Most of the other things that fall into this category are obvious. However, two dimensions of the protection extended to PGS works are not obvious and merit closer attention. The first is that nowadays, copyright law is often used to shield the logos that manufacturers apply to consumer products. Here's an example. The Omega Watch Company has obtained a U.S. copyright on this design, which it calls the Omega Globe design. From lecture number 1, you should remember how and why a Swiss company can get a U.S. copyright. Omega engraves a version of this logo on the underside of its watches, which are manufactured in Switzerland. Omega then sells these watches all over the world. Typically, it sells them for lower prices in poor countries than it does in more wealthy countries. Some years ago, Costco, using an intermediary, purchased some of the watches that Omega had sold cheaply outside the United States, imported them into the United States, and began selling them in its U.S. stores for prices lower than those used by Omega's authorized U.S. dealers. Omega brought suit, contending that this so-called parallel importation violated Omega's copyright in the logo, not its trademark or patent rights, but its copyright. Now, the legal rule underlying this lawsuit and the outcome of the suit we'll consider later when we discuss the rights of distribution and importation in lecture number 8. For now, I just want to emphasize the expansive reach of the subject matter of copyright and how companies like Omega have tried to use that expansive coverage to engage in geographic price discrimination. The second non-obvious dimension of the category of PGS works involves what is sometimes called applied art or industrial design. Those terms refer, roughly, to three-dimensional objects that are intended to be both useful and attractive. Objects of this sort permeate modern consumer culture. Just look around the room or space where you are located right now. Most likely, you'll notice many objects that fit this general definition. Possibilities include an unusual lamp, a container of bottled water, a distinctive coffee mug, the shape of a laptop computer or tablet, your eyeglasses if you wear them, a doorknob or window fixture, a decorative table or chair, and so forth. Each of these things combines in some way art and function. In the United States, 3 different systems of law are potentially available to the creators of new objects of this sort: copyright law, design patent law, and the protection that trademark law extends to so-called trade dress. Some innovations qualify on more than one of these systems, but others may fail to qualify under any. It depends on the shape and history of the particular object, and all too often on the whims of the tribunal evaluating that object. If you're curious about the potential reach of design patent law or trademark law, feel free to follow on your own the links in the relevant branches of the map using the interactive version of the map available through the CopyRightX website. For obvious reasons, I'll concentrate in this lecture on the possibility of copyright protection for objects of this sort. In the late 19th century, it was clear that copyright law did not extend to works of this sort. Three-dimensional works of fine art were shielded, but not the kind of consumer products to which I directed your attention a minute ago. Then gradually, through a series of steps itemized on the map, Congress, the Copyright Office, and the courts liberalized the relevant rules in the United States. Today, the governing general principle is that copyright protection is available to so-called useful articles if, and only if, the aesthetic and functional features of the article at issue are separable. The first step in applying this principle is to determine whether a particular object qualifies as a, quote, useful article, end quote, within the meaning of the copyright statute. The reason why this initial determination is so important is that if an object does not constitute a useful article, then the ordinary, more lenient rules of copyright law apply. Whereas if it does constitute a useful article, it has to pass more stringent tests. So what does useful article mean? The statute defines it as follows. Quote, an article having an intrinsic utilitarian function that is not merely to portray the appearance of the article or to convey information, unquote. Some applications of this definition will be straightforward. For example, Rodin's sculpture does not constitute a useful article because its function is to depict itself, to depict a thinker. By contrast, a lamp, no matter how beautiful, is a useful article because it has a function other than looking good, namely illuminating the room in which it's located. In other instances, however, application of this definition will be trickier. If a particular object is deemed to fall into this special category, then its creator gets copyright protection, to repeat, only if its aesthetic and functional dimensions are separable. How might they be separable? Traditionally, there were two options. The first of these options, which arises rarely, is that the aesthetic and functional dimensions might be physically separable. For example, as the treatise writer Melville Nimmer suggests, the stylized Jaguar shape that is attached to the hood of a Jaguar automobile enjoys copyright protection because it can be physically removed from the car without impairing the car's utilitarian function. Likewise, the utilitarian components of the car can be removed from the Jaguar without impairing its aesthetic features. With respect to most useful articles, physical separability of this sort is not feasible. The creators of such objects may still obtain copyright protection, however, if they can demonstrate that the aesthetic and utilitarian features are conceptually separable. So what does that mean? The conceptual separability inquiry is the most intriguing and least satisfying aspect of this doctrine. Until very recently, the United States Supreme Court provided very little guidance concerning how this concept should be interpreted and applied. As a result, the lower courts were forced to develop their own interpretations. By the early 21st century, 5 distinct families of interpretations of the term conceptual separability had emerged. The first of the 5 approaches asked whether the form of the object at issue is dictated by its function. If so, conceptual separability does not exist. This variant was emphasized by the majority of the judges in the influential 1985 Barnhart case, which involved these 2 sets of mannequins, which were copied by a competitor without permission. The majority, in that case, contended that the shapes of the mannequins were required by their function, namely displaying clothes in stores, and consequently, that their utilitarian and aesthetic features were inextricably combined and thus copyright protection was unavailable. The second of the 5 approaches asked which aspect of the object in question is primary. So, for example, the court in the Kesseltine cord case concluded that the ornamental aspect of these belt buckles was primary and their utilitarian function, namely holding pants up, was subsidiary, and thus that they did enjoy copyright protection. The third approach was made famous by Judge Newman's dissenting opinion in the Barnhart case, which I mentioned a minute ago. It came to be known as the, quote, temporal displacement test. The key question under this approach was whether the object, quote, stimulates in the mind of the beholder a concept that is separate from the concept evoked by its utilitarian function. If so, there is conceptual separability. If not, not. The phrase temporal displacement came from Newman's contention that the 2 concepts, utilitarian and non-utilitarian, must occur to the beholder not simultaneously, but separated in time. The fourth approach asked whether the article can stand on its own as a work of art. If so, it enjoys protection. There were two different ways of elaborating this. Paul Goldstein suggested that we inquire whether the article could constitute a work of art, quote, traditionally conceived, which is related, he argues, to whether the article would be equally useful without its aesthetic feature. The reference to art, quote, traditionally conceived, naturally draws us back into the debate I discussed in the first lecture concerning the best way of defining art. For the reasons I reviewed there, resolving that question would be difficult, although perhaps unavoidable. By contrast, Goldstein's fellow treatise writer, Nimmer, pointed to a more empirical interpretation, asking whether a significant number of copies of the article would be purchased if it had no utilitarian use. This approach was adopted by the Court of Appeals for the Fifth Circuit in the Galliano case, which involved uniforms for employees of the Harrah's gambling casino. Applying the test, the court concluded that the plaintiff, quote, makes no showing that its designs are marketable independently of their utilitarian function as casino uniforms, end quote, and therefore that the uniforms are not entitled to copyright protection. The fifth and last of the approaches focused on the intent of the creator of the article, the individual designer who determined its final shape. This approach was adopted by the Court of Appeals for the Second Circuit in the Brandeer case, which involved the following facts. David Levine was playing around with some wires, making miniature sculptures in his home. He twisted one wire into the shape of a bicycle and another into the shape of a ribbon and placed both, along with other designs, on his mantelpiece. A friend of his pointed out that the ribbon shape could serve as a useful rack for the miniature bicycle. Inspired, Levine worked with a friend to refine the design and eventually began manufacturing and selling commercial versions under the company name Brandeer International. His product is depicted on this slide. Here's another photo showing how bicycles can be locked to it. The rack proved popular, and a competitor, Cascade Pacific Lumber, began producing knockoffs. Brandeer brought a copyright infringement suit against Cascade. The outcome of the case hinged on whether the ribbon rack satisfied the conceptual separability test. Relying on a 1983 article by Robert Denicola, the court announced the following test. Quote, if design elements reflect a merger of aesthetic and functional considerations, the artistic aspects of a work cannot be said to be conceptually separable from the utilitarian elements. Conversely, where design elements can be identified as reflecting the designer's artistic judgment exercised independently of functional influences, conceptual separability exists. Applying this approach, the court ruled against Brandeer, emphasizing several ways in which Levine had modified the shape of the original abstract sculpture in order to make it durable and to accommodate as many bicycles and mopeds as possible. Because the shape of the product did not reflect, quote, artistic expression uninhibited by functional considerations, it could be copied by a competitor with impunity. As one might expect, the result of this decision was that other companies began manufacturing and selling competing versions of the ribbon rack. In 2016, the divergence of views among the various courts of appeals on the proper approach to conceptual separability prompted the United States Supreme Court to attempt to settle the matter. The case in which the court addressed the issue involved the following facts. Cheerleaders in the United States entertain the fans who attend sporting events. Typically, they wear brightly colored uniforms, perform gymnastic maneuvers, and encourage the fans to cheer on the team hosting the event. Although the cheerleaders at college-level competitions are best known, in part because those competitions are often televised, quite young people, often, though not always girls, participate in this activity. The Varsity Brands Company designs, manufactures, and sells cheerleading uniforms. Two of their products are shown in this photo. Varsity has applied for and been granted copyright registrations on many of their designs. The drawings submitted in conjunction with 5 of those registrations are shown on this slide. The Star Athletica company also manufactures and sells cheerleading uniforms. Allegedly, Star produced and sold uniforms that incorporated these 5 of Varsity's designs. Varsity brought suit for copyright infringement. The crucial issue in the case was whether Varsity's designs qualified for copyright protection at all, and that issue reduced to the issue of whether the design and function of the uniforms were separable. The trial court concluded no, the Court of Appeals for the Sixth Circuit concluded yes, and the Supreme Court, seeking to resolve the conflict among the various courts of appeals on this general question, agreed to hear the case. In the end, the court, by a vote of 6-2, upheld the Sixth Circuit's judgment that the uniforms did enjoy copyright protection. The majority opinion, written by Justice Thomas, announced a new test for separability, which will govern all future cases involving useful articles. The key components of the new test are set forth on your screen. Quote, "We hold that an artistic feature of the design of a useful article is eligible for copyright protection if the feature, 1, can be perceived as a 2- or 3-dimensional work of art separate from the useful article, and 2, would qualify as a protectable pictorial, graphic, or sculptural work either on its own or in some other medium if imagined separately from the useful article." This new test, you should recognize, is a variation on the separate concept test originally developed by Judge Newman, although oddly, Justice Thomas did not acknowledge as much. In his justification for this approach, Thomas expressly repudiated some of the other tests: Goldstein's variant of the standalone test, Nimmer's variant of the standalone test, and the intent of the creator test that, as we saw, drove the Brandeer bike rack case. Implicit in Thomas's opinion is repudiation of the other pre-2017 approaches. The application of this new approach to the facts of the case, just as Thomas contended, was simple. One can easily identify the decorations on the uniforms as features having pictorial, graphic, or sculptural qualities, thus satisfying Test 1. As to Test 2, if the arrangement of colors, shapes, stripes, and chevrons on the surface of the cheerleading uniforms were separated from the uniform and applied in another medium, they would of course qualify as 2-dimensional works of art. We don't yet know how this new approach will be interpreted and applied by the lower courts, but already many legal commentators have weighed in, and the large majority have expressed disappointment or dismay. To be sure, a few aspects of the STAR test have been praised. For example, by rejecting the subjective intent of the creator test, the Supreme Court has probably limited the scope of discovery in cases of this sort, thus sharply reducing litigation costs, as well as curbing wasteful strategic behavior by designers. And, as Jane Ginsburg points out, the new approach has reduced to some degree the relevance of whether an artistic design is first developed in 2 dimensions and then applied to a useful article, or incorporated in a useful article straight away. All to the good. But other aspects of Thomas's approach have been sharply criticized. Almost all commentators agree that it is distressingly vague and thus gives poor guidance to litigants and lower courts. Some commentators contend that it is too easily satisfied and thus will expand dramatically the set of useful articles that enjoy copyright protection. Others, like Mark McKenna, lament the absence of any discussion in the court's opinion of the policies or theories underlying the separability requirement, which in turn reduces the chances that, when applied, the new test will be either coherent or socially beneficial. Whether these criticisms are well-founded remains to be seen. This leaves us with one more type of three-dimensional object that now enjoys copyright protection: architecture. Inclusion of architecture in the list was a long time coming, and its implications are still not entirely clear. Here's a bit of background. The original 1886 version of the Berne Convention included architectural plans in the set of things that member countries were obliged to protect, but not architectural works per se. Application of this principle would mean that if you copied the drawings that an architect had prepared to guide the construction of a building, you would be liable for infringement, but not if you were able to construct an identical building without use of those plans. In 1890, the Belgian scholar Jules de Bourschgrave published an article criticizing this state of affairs and arguing that works of architecture deserve protection identical to that enjoyed by other works of art, such as painting and music. Bourschgrave's argument slowly took root in European copyright systems, first in Belgium, then in France. For a while, some European countries resisted adoption of his proposal on the ground that it could prevent replication of ordinary, non-innovative buildings. But when reassured that the proposal would only apply to, quote, original artistic work, end quote, they acquiesced. A key step in this campaign was the addition of architectural works to Article 2L of the 1908 version of the Berne Convention. As you know, the United States did not join the Berne Convention until 80 years later. Until it did so, copyright protection for architecture in this country was skimpy. Again, architectural plans were shielded, as they were in most countries, so that unauthorized reproduction of such plans was unlawful. However, the majority view in the United States was that an architect whose plans were copied without his permission could not permit the construction of buildings using the infringing plans. The buildings themselves were potentially protectable as useful articles, just like the types of industrial design we have recently considered, but as such, they had to satisfy the conceptual separability test. Only if the aesthetic components of a building were separable from the utilitarian features did the building enjoy protection against non-permissive copying. Rarely was this true. When the United States did finally join the Berne Convention, Congress considered whether formally to extend copyright protection to architectural works. It initially decided not to do so, persuaded that the protections available for useful articles were adequate, but it commissioned a report from the Copyright Office on the subject, and that report urged that the law be modified. Congress, in response, adopted the Architectural Works Copyright Protection Act, which became effective in 1990. The key provisions of the new statute are set forth on your screen. Notice that it's limited to, quote, architectural works, which are defined as, quote, the design of a building. Courts in the United States have construed building to be limited to freestanding structures. The most important implication of this new statute is that in the United States, architectural works no longer have to run the gauntlet of the conceptual separability test in order to be protected. To be sure, like all types of copyrighted work, a piece of architecture must be original to be protectable, but as we've seen, the standard for originality is very lenient. Here's an example of a building design that would clearly pass muster. In 1989, the Polish-born architect Daniel Libeskind won a competition to design the Jewish Museum in Berlin. Here's a photograph of the building, taken from directly above it, and a second aerial photograph, taken from a slight angle. As you can see, the shape of the building is unusual, a complex zigzag. Here's how Libeskind himself explained the structure. His architectural partner and wife, Nina Libeskind, emphasized the theme mentioned at the end of the second paragraph, likening the shape of the building to a broken Star of David. In the late 1990s, the Australian architect Howard Ragat was commissioned to design the new National Museum of Australia to be located on this peninsula in the center of Canberra. Ragat's much celebrated design is shown in these aerial photos. Until the Australian Museum had been finished, no one apparently noticed the resemblance between its central building and the Jewish Museum in Berlin. But once the connection was suggested, the parallelism became unmistakable. This case never resulted in litigation. Had it done so, it most likely would have resulted in liability. Since 1968, Australian copyright law has extended to, among other things, a building or model of a building, whether the building or model is of artistic quality or not. Certainly, if this standard is construed in the same way the current U.S. standard is construed, Libeskind's design would qualify for protection, and the Australian building resembling it sufficient to satisfy the legal standard of substantial similarity. The fact that the case nevertheless was not litigated bears emphasis. Why not? We can't be sure, but probably two factors were at work. First, copyright litigation is very time-consuming and expensive. As a result, only a tiny percentage of potentially actionable cases ever end up in court. Second, architects, at least high-end architects, seem especially loath to rely on copyright to protect their work. As David Shipley notes, the large majority of the cases that have been brought alleging violations of the Architectural Works Copyright Protection Act involve not high-end buildings, but mundane, mass-produced works. The designers of noteworthy buildings, by contrast, seem to rely more on peer pressure and public condemnation to discourage knockoffs. Indeed, such extra-legal sanctions were deployed in this particular instance. The Libeskinds publicly expressed outrage, and the press, both in Germany and in Australia, condemned what one paper called, quote, architectural kleptomania. The director of the Australian Museum, who apparently had not known of the relationship between the two buildings, expressed some misgivings, publicly acknowledging that, quote, had we known, we might well have asked for that particular reference not to be included, end quote. Interestingly, however, Ragat himself seems to have had no regrets. The overall design of the Australian Museum is postmodern in character, alluding to many other structures. Ragat readily admitted to having been inspired by the Jewish Museum, and does not seem to resist the inference drawn by many observers that he deliberately intended to analogize the treatment of Aborigines in Australia to the treatment of the Jews in the Holocaust. As one might imagine, that suggestion remains highly controversial in Australia. The more general point latent in this example is that there is no consensus, even among architects, concerning the definition and significance of copying when it comes to designs of buildings. What to one person constitutes plagiarism or theft may to another seem quotation or allusion. The law now sides with the former, but is rarely invoked. What the relevant norm should be is one of the questions I hope you'll be in a position to answer. This concludes lecture number 3. Next week, we'll return to copyright theory, examining in some detail the utilitarian approach. The week after that, we'll return to law and discuss authorship.